Good afternoon, Your Honor. This is case number IT-0145I, the prosecutor versus Ante Gotovina.
I thank you, Madam. Mr. Gotovina, good afternoon to you. I want to make sure that you are able to follow the proceedings in your own language. In other words, that you are receiving interpretation. You have to say yes or no.
Yes.
Thank you. Please, you can remain seated for the time being. If at any time you're not receiving interpretation in a language that you can understand, or if the reception of the interpretation is not satisfactory, either because the sound level is not correct or for any other reason, please draw my attention straight away. It's very important that throughout the entire sitting you are able to follow the proceedings at any given moment. Appearances. Could I have the appearances for the prosecution, please?
Good afternoon, Your Honor. On behalf of the prosecution, my name is Alex Whiting. I'm joined today on my left by Ms. Lori Sartorio, Ms. Catherine Gallagher, behind me Ms. Heike Bach, and our case manager, Ms. Lakshmi Walpida.
I thank you, Mr. Whiting, and good afternoon to you and your team. I know, because I have been informed, that the registrar has appointed a duty counsel to look after the interests of the accused for today's initial appearance. Mr. Knoeps, could you identify yourself, please, and confirm what I have just stated?
Thank you, Your Honor. Good afternoon. My name is Geert-Jan Alexander Knoops. I'm indeed appearing as duty counsel for the accused.
I thank you and good afternoon to you, Mr. Knoops, and I thank you so much on behalf of the Tribunal for having accepted this onus for today. Now, Mr. Gotovina, before I proceed any further, it is my duty here to explain to you that you have a fundamental right here to remain silent throughout the entire proceedings. In other words, no one can force you to answer any question that may be put to you as we proceed. And before we come to the most important part of the initial appearance, I have decided that I will give some details, explain some of the details of the indictment, and about the indictment itself. The accused Ante Gotovina was included in the indictment with case number IT-0145, which was signed on the 22nd of May 2001, filed on the 31st of May of that year, and which was kept under seal. That indictment was confirmed by my colleague Judge Fuad Riyad on the 8th of June 2001 and kept under seal. An amended indictment was also kept under seal, was filed by the OTP, by the Office of the Prosecutor, on the 19th of February of last year, 2004. And that indictment, that amended indictment, was confirmed by my colleague Judge Kevin Parker on the 24th of February of that year. On the 8th of March 2004, Judge Parker issued an order making public the amended indictment that he had confirmed. The accused, as everyone knows now, was arrested in Tenerife, Spain, on Wednesday, the 7th of December 2005, And last Saturday, that's the 10th of December, he was transferred to The Hague, that is the seat of this tribunal. Before I proceed any further, let me give you some information on the details of the indictment against you, Mr. Gotovina. This will help you understand the nature of the charges that the prosecutor has brought against you in virtue of the indictment that will be read out to you later on. And also my explanation will help members of the public following these proceedings to understand what these proceedings are all about and what you are being charged with. The amended indictment alleges that you, Mr. Gotovina, you were born on the 12th of October 1955 on the island of Pasman within the municipality of Zadar in the Republic of Croatia, which then formed part of the Socialist Federal Republic of Yugoslavia. According to the prosecutor, at all times relevant to the indictment, you were the commander of the split operative zone of the Croatian army, Hrvatska Vojska. It is also alleged in the indictment that you were also the overall operational commander of the Croatian forces that were deployed as part of Operations Storm in the southern portion of the Krajina region. According to the indictment, the so-called Operation Storm was a military offensive launched by the Republic of Croatia on the 4th of August 1995 with the specific objective of retaking the Krajina region, including the municipalities, in whole or in part of Benkovac, Gračac, Knin, Obrovac, Šibenik, Sinj, and Zadar. While the Croatian government announced Operation Storm had been successfully completed by the 7th August of 1995, it is indeed being alleged that follow-up actions continued until about the 15th of November of 1995. The amended indictment alleges that during and after Operation Storm, Croatian forces attacked and took control of towns, villages and hamlets in the southern portion of the Krajina region, during which they subjected the local Serb population to persecutions and plundered and destroyed their property in the municipalities of Benkovac, Donji Lapac, Drniš, Gospić, Gračac, Knin, Korenica, Obrovac, Šibenik, Sinj and Zadar, thereby forcing the Krajina Serbs to flee. The amended indictment further alleges that Croatian forces killed at least 150 Serbs in Krajina while subjecting large numbers of others to inhumane treatment, humiliation and degradation. Mr. Gotovina, you are charged with 4 counts of crimes against humanity under Article 5 of the statute of this tribunal, and with 3 counts of violations of the laws and customs of war under Article 3 of the statute of this tribunal. The amended indictment alleges also that a joint criminal enterprise of which you formed part together with others, including Ivan Čermak and Mladen Markac, who you know are already here, and also the late President of Croatia, Franjo Tuđman, existed, and that the purpose of this joint criminal enterprise was the forcible and permanent removal of the Serb population from the Krajina region, including by plundering, damaging or destroying the property of the Serb population so as to discourage or prevent members of that population from returning to their homes. You are further charged in terms of the amended indictment with individual criminal responsibility pursuant to Article 7.1 of our statute, and that is for having, acting individually or in concert with others, planned, instigated, ordered, committed, or otherwise aided and abetted in the planning, preparation, or execution of the crimes charged in the amended indictment, or that you foresaw the likelihood that they would be committed. Then you are also charged under Article 7.3 of our statute with superior command responsibility. The prosecution is alleging that you knew or had reason to know that all crimes alleged in the amended indictment were about to be committed or had been committed by your subordinates, and that indeed you failed to take the necessary and reasonable measures to prevent such acts or to punish the perpetrators thereof. The prosecution alleges in the amended indictment that all the crimes mentioned therein occurred between the 4th of August 1995 and the 15th of November of that year in the southern portion of the Krajina region and were directed against the Serb population in the territory of the Krajina region. The Vice President of this tribunal, Judge Parker, acting as President, by order dated the 9th of December 2005, assigned this case, your case, to my trial chamber, that is Trial Chamber 2. I am the President of Trial Chamber 2, and in an order which I signed this morning, I designated myself as pre-trial judge for the purpose of the initial appearance of the accused. I will now proceed to the more substantive part of the initial appearance in accordance or as required by our rules. And the relative rule is Rule 62. And once I have gone through these preliminaries, then I will move to the most important formality of this initial appearance, and that is formally charge you and ask you whether you wish to enter a plea to the charges brought against you today or later, and what kind of plea you wish to enter in any case. Now, Mr. Gotovina, could you please stand up? Now, my first responsibility relates to representation. You may have noted, you would have noted for sure, that earlier on I mentioned that I was noticing the presence in the courtroom of Mr. Knoeps, who I understood had been appointed as duty counsel by the registrar to represent you for the purpose of today's initial appearance only. You are aware of that, Mr. Gotovina, aren't you?
Yes, I am.
I thank you. And would you like to say anything in relation to your being represented this afternoon by Mr. Knoeps?
Your Honor, I have nothing to say.
Thank you. Rule 62 requires of me to put to you a series of questions before then I charge you formally and ask you if you wish to enter a plea. Could you please give me your full name for the record?
Ante Gotovina.
Ante Gotovina.
Do you have any nicknames by which you are referred to?
No.
Could you give me your date of birth, please?
The 12th of October, 1955.
I thank you. And your place of birth, please?
Zadar.
Zadar.
I am going to ask you now the address at which you resided, your last address at which you resided before you arrived here. I'm giving you the option to tell me that, if you wish so, in open session, in public session, or in private session. Private session would mean that only the persons inside these four walls here, and therefore excluding the members of the public, would hear what you have to say. What's your choice?
Tenerife.
Tenerife, the Canary Islands,
Španjolska.
in Spain.
Do you have a specific address that you could give me?
Ne,
No.
ne časni sude, ne.
Oh, Your Honor, I don't.
Right, thank you. Now I want to make sure that the members of your family have been informed about your transfer to The Hague and also your state of detention in the UN detention unit here in The Hague. Can you confirm that to me, please?
Da, mogu časni sude.
Yes, Your Honor.
Have you had an opportunity to contact the members of your family?
Sam časni sude.
Yes, Your Honor.
I also want to make sure that your embassy, the embassy of the Republic of Croatia, has been informed of your presence and detention here in The Hague. I would take it that the embassy has been informed, but are you aware as to whether the embassy has been informed or not?
Časni sude.
Your Honor, they have been informed.
Thank you. Do you require me to do anything on your behalf as regards contacting your family or any member from the Embassy of the Republic of Croatia?
Časni sude.
Thank you very much, Your Honor.
Thank you. Mr. Gotovina, please do sit down. The purpose of your arraignment here today is not only to formally charge you and ask you to enter a plea, but to publicly inform you of certain rights, very important rights that you enjoy, both under international law, but also in terms of our statute and our rules. Indeed, I'm going to ask the registrar to read out to you the relevant passages from the statute of this tribunal, particularly Articles 20 and 21 of our statute. And then I will add a few words of my own and proceed to make sure that you have understood or that you understand fully the nature and the importance of these rights that you enjoy now and also later throughout the continuance of all these proceedings against you. Madam Registrar, could you kindly read out slowly and in English Article 20 of the Statute of the Tribunal, after which you can then proceed to read Article 21. Thank you.
Yes, Your Honor. Article 20, Commencement and Conduct of Trial Proceedings. 1. The trial chambers shall ensure that a trial is fair and expeditious, and that proceedings are conducted in accordance with the rules of procedure and evidence, with full respect for the rights of the accused and due regard for the protection of victims and witnesses. 2. A person against whom an indictment has been confirmed shall, pursuant to an order or an arrest warrant of the International Tribunal, be taken into custody, immediately informed of the charges against him, and transferred to the International Tribunal. 3. The trial chamber shall read the indictment, satisfy itself that the rights of the accused are respected, confirm that the accused understands the indictment, and instructs the accused to enter a plea. The trial chamber shall then set the date for trial. 4. The hearings shall be public unless the trial chamber decides to close the proceedings in accordance with its rules of procedure and evidence. Article 21, Rights of the Accused. 1. All persons shall be equal before the International Tribunal. 2. In the determination of charges against him, the accused shall be entitled to a fair and public hearing, subject to Article 22 of the statute. 3. The accused shall be presumed innocent until proved guilty according to the provisions of the present statute. 4. In the determination of any charge against the accused, pursuant to the present statute, the accused shall be entitled to the following minimum guarantees in full equality. A. To be informed promptly and in detail, in a language which he understands, of the nature and cause of the charge against him. B. To have adequate time and facilities for the preparation of his defense and to communicate with counsel of his own choosing. C. To be tried without undue delay. D. To be tried in his presence and to defend himself in person or through legal assistance of his own choosing. To be informed, if he does not have legal assistance, of this right, and to have legal assistance assigned to him in any case where the interests of justice so require, and without payment by him in any such case if he does not have sufficient means to pay for it. E. To examine, have examined, the witnesses against him and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. F. To have the free assistance of an interpreter if he cannot understand or speak the language used in the tribunal. G. Not to be compelled to testify against himself or to confess guilt.
I thank you so much, Madam. Mr. Gotovina, do you understand the importance of these rights, which Madam Registrar has just read out to you?
Časni sudac.
Your Honor, I have.
Do you wish me to explain any of these rights before we continue?
Časni sudac smatram.
Your Honor, I feel there's no need for that.
I will tell you. You may sit down. I will tell you a couple of things. Namely that in this tribunal, every accused is entitled to self-representation. In other words, every accused can opt to defend himself or herself. That's number one. Alternatively, an accused can also ask to be represented by a counsel of his own choosing. That right is not absolute. In other words, you cannot bring forward any person you like, however qualified that person may be in your own mind, to represent you. We have our own rules and standards by which we operate, and that person, before being able to represent you, must first be approved by the registrar. We also have in place a system of legal aid, which may or may not be applicable to you in this case. That depends on an assessment that the registrar makes after consultations with you, and maybe investigations too. We only intervene if you disagree with the assessment of the registrar, and only if we come to the conclusion that the registrar has exercised his discretion unreasonably and in a manifestly so. You also have the right under Rule 65 of our tribunal to ask to be released provisionally under bail. I'm sure that you will be advised on this, whether it's the case of filing such a request or not by the counsel that will be assisting you. Last but not least is that later on you will be appearing before the trial chamber regularly until we come to trial, and I'll explain the procedure very shortly. And each time you appear, you enjoy the right that I mentioned to you in the very beginning, namely that you have a right to remain silent, and that you cannot at any moment be compelled to state anything or to testify against yourself or confess any guilt. Mr. Gotovina, have you been served with a copy of the amended indictment in your own language?
Tako je, časni sud.
Yes, Your Honor.
Have you read it?
Upoznat sam.
I have, and I have understood it.
All right, I thank you. That spurs me having to put the next question. Now, rules require me to read out the amended indictment to you. I know because I have been informed already that you were prepared to waive this right and take the amended indictment as read. However, I think that given that you have been a fugitive for the past 4 years, and that for most of the time this indictment was kept under seal, I think I owe it to everyone that the indictment is read out in full. So please make yourself comfortable, and Madam Registrar would kindly read out the entire indictment in full. When we come to the appendixes, I'll tell you what's going to happen. Madam Registrar.
Yes, Your Honor. The prosecutor of the International Criminal Tribunal for the former Yugoslavia, pursuant to her authority under Article 18 of the Statute of the International Criminal Tribunal for the former Yugoslavia, charges Ante Gotovina with crimes against humanity and violations of the laws and customs of war, as set forth below. The accused, Ante Gotovina, was born on 12th of October 1955 on the island of Pašman within the municipality of Zadar in the Republic of Croatia, then part of the Socialist Federal Republic of Yugoslavia. Ante Gotovina, a former French legionnaire of the rank of chief corporal, returned to Croatia in June 1991, whereupon he was appointed Chief of Operations and Training of the 1st Brigade of the Zbor Narodne Garde, National Guard Corps. From February to April 1992, he was deputy to the commander of the special unit of the main staff of the Croatian Army, the Hrvatska Vojska, the HV. And from April to October 1992, he was assigned to the Croatian Defense Council, Hrvatsko Vijeće obrane, the HVO. On the 9th of October 1992, Ante Gotovina, holding the rank of brigadier, was appointed the commander of the split operative zone of the HV, which in 1993 was renamed the Split Military District, and held that command until March 1996. On the 30th of May 1994, he was promoted to the rank of Major General. By early August 1995, he had been promoted to the rank of Colonel General. On the 4th of August 1995, the Republic of Croatia launched a military offensive known as Alleges, or Storm, Operation Storm, with the objective of retaking the Krajina region. Ante Gotovina was the overall operational commander of the Croatian forces that were deployed as part of Operation Storm in the southern portion of the Krajina region, including the municipalities in whole or in part of Benkovac, Gračac, Knin, Obravac, Šibenik, Sinj, and Zadar. On the 7th of August 1995, the Croatian government announced that the operation had been successfully completed. Follow-up actions continued until about the 15th of November 1995. In early August 1995, following the retaking of the Krajina region, Ante Gotovina moved his headquarters to Knin, the capital of the Krajina region, which was located within the Split Military District. On the 12th of March 1996, the President of the Republic of Croatia, Franjo Tuđman, President Tuđman, appointed Ante Gotovina Chief of the HV Inspectorate. Individual and superior criminal responsibility. Ante Gotovina is individually criminally responsible for the crimes which are referred to in Articles 3 and 5 of the Statute of the Tribunal, and which are alleged in this amended indictment pursuant to Article 7(1) of the Statute of the Tribunal. Acting individually or in concert with others, the accused planned, instigated, ordered, committed, or otherwise aided and abetted in the planning, preparation, or execution of such crimes, or foresaw the likelihood that they would be committed. By using the word committed in the amended indictment, the prosecutor also includes acts that the accused committed by participating in a joint criminal enterprise. During and after Operation Storm, at all times relevant to this amended indictment, Ante Gotovina, with others, included Ivan Chermak, Mladen Markic, and President Franjo Tudjman, participated in a criminal joint enterprise, the common purpose of which was the forcible and permanent removal of the Serb population from the Krajina region, including by plunder, damage, or outright destruction of the property of the Serb population, so as to discourage or prevent members of that population from returning to their homes and resuming habitation. The crimes enumerated in counts 1 and 3 to 6 of this amended indictment were within the common purpose of the joint criminal enterprise. The accused had the state of mind necessary for the commission of these crimes. The crimes enumerated in counts 2 and 7, and as an alternative to the allegations in paragraph 8, counts 1 and 3 to 6 were the natural and foreseeable consequences of the execution of the joint criminal enterprise, and the accused was so aware. During Operation Storm and its aftermath, Croatian forces attacked and took control of towns, villages, and hamlets in the southern portion of the Krajina region. Pursuant to the orders of Ante Gotovina, these forces carried out the acts which give rise to counts 1 and 3 to 6. By his acts and omissions, the accused thereby encouraged others, including Croatian civilians, to also perpetrate those acts that give rise to those charges. Further, the accused, Ante Gotovina, had a duty to restore and ensure public order and safety, and he failed to fulfill this duty. As the overall operational commander, Ante Gotovina exercised de jure and or de facto command and control over Croatian forces during Operation Storm. In the aftermath of Operation Storm, Ante Gotovina retained command and control of HV forces that continued to be deployed in the southern portion of Krajina region. Ante Gotovina, while holding a position of superior authority, is also individually criminally responsible for the acts or omissions of his subordinates, pursuant to Articles 7.3 of the Statute of the Tribunal. A superior is responsible for the criminal acts of his subordinates if he knew or had reason to know that his subordinates were about to commit such acts or had done so, and the superior failed to take the necessary reasonable measures to prevent such acts or to punish the subordinates. Ante Gotovina had the power, authority, and responsibility to prevent or punish serious violations of international humanitarian law committed by Croatian forces during and after Operation Storm. The accused knew or had reason to know that all crimes alleged within this amended indictment were about to be committed or had been committed by his subordinates, and he failed to take necessary and reasonable measures to prevent acts or to punish the perpetrators thereof. The accused is therefore individually criminally responsible under Article 7.3 of the Statute of the Tribunal. General allegations. At all times relevant to this amended indictment, a state of armed conflict existed in the Krajina region of the Republic of Croatia and the territory of the former Yugoslavia. At all times relevant to this amended indictment, the accused, Ante Gotovina, was required to abide by the laws and customs governing the conduct of war, including Common Article 3 of the Geneva Conventions of 1949. The acts or admissions alleged against the accused in this amended indictment, which constitute crimes against humanity, are crimes punishable by Article 5 of the Statute of the Tribunal, and were part of a widespread systematic attack directed against a civilian population, namely the Serb population of the southern portion of the Krajina region. In this amended indictment, every reference to Croatian forces means and includes those units of the HV, the Croatian Air Force, or the HRZ, and units of the RH MUP that participated in Operation Storm and or its aftermath, and also the civilian and special police in the southern part of the Krajina region. The count in the amended indictment in relation to murder and the count of persecution insofar as it relies on the acts of murder allege the totality of these acts. The schedule to these counts set forth only a small number of individual incidences for the purpose of specificity of pleading. The general allegations contained in the previous paragraphs are realleged and incorporated into each of the relevant charges set out below. Count 1, persecution. Between the 4th of August 1995 and the 15th of November 1995, the accused Ante Gotovina, acting individually and or in concert with other members of the Joint Criminal Enterprise, planned, instigated, ordered, committed, or otherwise aided and abetted in the planning, preparation, or execution of persecutions of the Krajina Serb population in the southern part of the Krajina region. The crimes of persecutions was perpetrated through the following. Plunder of public or private property. Between the 4th of August 1995 and the 15th of November 1995, Croatian forces systematically plundered the property of the Krajina Serbs, including their homes, outbuildings, barns, and livestock in the towns, villages, and the hamlets of the municipalities of Benkovac, Donji Lapac, Drniš, Gospić, Gračac, Knin, Koranica, Obravac, Šibenik, Sinj, and Zadar. Destruction of property. Between the 4th of August 1995 and the 15th of November 1995, Croatian forces systematically set fire to or otherwise destroyed villages, homes, outbuildings, and barns belonging to the Krajina Serbs, killed their livestock, and spoiled their wells. Thousands of dwellings in the municipalities of Benkovac, Donji Lapac, Drniš, Gospić, Gračac, Knin, Koranica, Obravac, Sibenik, Sinj, and Zadar were damaged or destroyed. Deportation, forced displacement. Between the 4th of August 1995 and the 15th of November 1995, Croatian forces directed violent and intimidating acts against Krajina Serbs, including the plunder and destruction of their property, thereby forcing them to flee the southern portion of the Krajina region. These acts were intended to discourage or prevent those who had already fled the area, either immediately before or during Operation Storm, in anticipation of an armed conflict, from returning to their homes. The effect of these violent and intimidating acts was a deportation and or displacement of tens of thousands of Krajina Serbs to Bosnia and Herzegovina and Serbia. The prosecution alleges that the following two acts were natural and foreseeable consequences of the joint criminal enterprise, and on that basis also contributed to the offense of persecutions. Murder. Before the 4th of August 1995 and 15th of November 1995, Croatian forces murdered at least 150 Krajina Serbs. Specifically referred to in this amended indictment are the murders of one person in the Benkovac municipality, 30 persons in the Knin municipality, and one person in the Krajina municipality. Other inhumane acts. Between the 4th of August 1995 and the 15th of November 1995, large numbers of Krajina Serbs were subjected to inhumane treatment, humiliation, and degradation by Croatian forces, beating and assaulting them. Alternatively,